we will read fundamental right that is mentioned in part 3 of Indian Constitution, covering article 12 to article 35. So fundamental right is mentioned in part 3 of Indian Constitution, covering article 12 to article 35. The framers of our Indian Constitution have derived inspiration from the Constitution of USA and have incorporated fundamental rights in Indian Constitution. The Bill of Rights mentioned in USA Constitution is the source of inspiration for the incorporation of fundamental right in Indian Constitution in part 3. So Bill of Rights of American Constitution is the source of inspiration for us to incorporate fundamental rights in our Constitution in part 3. When I was teaching you the preamble to Indian Constitution, that in preamble we have already read that in preamble there are some goals or objective mentioned. And what are those objectives mentioned? What are those goals mentioned in preamble of Indian Constitution? And those goals are equality, liberty, then justice, dignity of individual. So these are the goals or objectives that are mentioned in preamble. That means these are the goals that India wants to achieve. And these goals or objectives mentioned in preamble are ensured by fundamental rights mentioned in part 3 of Indian Constitution. For example, equality is ensured by Article 14 to Article 18. Liberty is ensured by Article 19 to Article 22. Then dignity of individual is ensured by Article 21. So fundamental rights ensure that the goals mentioned in preamble are achieved. Apart from fundamental right, the directive principle of state policy mentioned in part 4 of Indian Constitution and fundamental duties mentioned in part 4A of Indian Constitutions are also important in achieving goals mentioned in preamble. And if you see, then fundamental right, it regarded as negative obligation of the state. Why this is regarded as negative obligations to the state, that you will understand if you read the article mentioned in fundamental rights. For example, if you read Article 14, then it says that the state shall not deny to any person equality before law and equal protection of the law. That means the wording of the article is that the state shall not discriminate. Then if you see the Article 15, then it is written that the state shall not discriminate on the basis of race, religion, caste. So that means the wording of the article mentioned in fundamental right is that state shall not do something, state shall not do this thing, state shall not do that thing. That means what state should not do is mentioned in fundamental right. That means these articles are negatively worded, and that is why it is being said that fundamental rights are negative obligations of the state. That means it is fundamental rights is saying to the government, saying to the state that state cannot do these things. So fundamental rights are negative obligations of the state. And fundamental right ensures political democracy. It ensures political democracy, and also fundamental rights ensure doctrine of limited government. That means, so the doctrine of limited government means government should not have unlimited power. Government should act with limited power. And who ensures that government is acting within a limited power? This is fundamental right. So fundamental right is ensuring that government is acting within limited power. So fundamental right ensures doctrine of limited government by putting some restriction on the state, that state shall not do these kind of things. So fundamental rights promotes political democracy, and fundamental rights, by putting restriction on the state, it is ensuring doctrine of limited government as well. Now we'll divide rights into two categories. Now what is rights? Right means something, some entitlements that you have. So entitlements. Now we can divide rights into two categories. One is constitutional right and another one is statutory right. Now what is constitutional right? Constitutional rights are those rights which are mentioned in the constitution. And which are statutory rights? Statutory rights are those rights which are given by laws of legislature, that means parliament. That means the rights which are mentioned in the Constitution of India are called as constitutional right, and the rights which are given to you by the laws of legislature, by the laws of parliament, are called as statutory rights. Now we can divide constitutional rights into two parts. One is fundamental right and other is, we can term it as other constitutional right. Now what is this fundamental right? Fundamental rights are those rights which are mentioned in part 3 of Indian Constitution. So within the constitution, within the constitutional right, we are dividing it into two categories. One is fundamental right, that means the rights which are mentioned in part 3 of Indian Constitution, we are calling them fundamental rights. And another category is other constitutional rights, that means the rights which are mentioned in the constitution apart from part 3. So we are classifying the rights under constitution into two categories. One specifically which are mentioned in part 3, we are calling them fundamental rights, and apart from part 3 of the constitution, the other rights that are mentioned in the constitution is called as other constitutional rights. If I give example of other constitutional right, then article 300A, right to property. Although this right to property was originally part of fundamental right, but now presently it is part of article 300A and it comes under other constitutional rights. Then you have article 301, which talks about right to interstate business. So these are other constitutional rights which are outside the part 3 of Indian Constitution but present in Indian Constitution. And statutory rights are those rights which are given by laws of legislature, laws of parliament. For example, Right to Information Act. For example, Mahatma Gandhi National Rural Employment Guarantee Scheme, Guarantee Act. So these are the rights given to you by the laws of legislature. That means this is called statutory rights. And what is the speciality of fundamental right is that if the fundamental rights are violated, then you can directly approach the Supreme Court of India. That means if the fundamental rights are violated, then you can directly approach the Supreme Court of India. And if your other legal rights are violated, then also you can move to court, but then you have to follow the procedure that first you have to go to local court, then by way of appeal to High Court, and then to Supreme Court. But in case of fundamental right, if your fundamental rights are violated, you can directly approach the Supreme Court of India. This is the speciality of fundamental right. Now, why these rights are called fundamental, we will see now that. So, these rights are called fundamental rights because these are guaranteed and protected by Constitution of India. And what is Constitution of India? It is the fundamental law of the land. It is the fundamental law of the land. That means the rights that are guaranteed and protected by the fundamental law of the land, those rights are called fundamental rights. And there is also another reason why these rights are called as fundamental rights, is because these rights are very much essential for the overall development of an individual. So these are called fundamental in the sense that they are the most essential thing for the all-round development of the individual. That means if someone wants to develop fully, then he wants liberty, he wants equality. Otherwise, he or she cannot grow to the fullest potential. So fundamental rights are those rights which are most essential for the all-round development of the individual. Now we'll see how many fundamental rights are there. So if we see the original constitution, then the original constitution provided for 7 fundamental rights. And what are those 7 fundamental rights? Those are right to equality. Those are mentioned in Article 14 to Article 18. Then right to freedom, which are mentioned in Article 19 to Article 22. Then right against exploitation, these are mentioned in Article 23 and Article 24. Then right to freedom of religion, that is mentioned in Article 25 to Article 28. And then we have cultural and educational rights mentioned in Article 29 and 30. And then right to property mentioned in Article 31. And then right to constitutional remedies mentioned in Article 32. But this right to property that was mentioned in Article 31 is deleted from the list of fundamental rights. And when it was deleted from the list of fundamental rights, this was deleted from the list of fundamental rights through 44th Constitutional Amendment Act 1978. And from then onwards, currently, this is a legal right which is mentioned in Article 300A of Indian Constitution and of Part 12 of Indian Constitution. So currently, at present, 6 fundamental rights are present in Indian Constitution. Now, if you read the fundamental rights mentioned in Article 14 onwards, then you will get to see that it is written the state shall not do this thing, the state shall not discriminate on the basis of these things, the state shall not do all these things. So there is a word called state. Now what is the state? So who is the state? So definition of state is mentioned in Article 12 of Indian Constitution. So Article 12 of Indian Constitution defines what is the state for the purpose of fundamental rights. And who all are included under the definition of state? So under the definition of state mentioned in Article 12, there is Government of India, then Parliament, that is legislature, Parliament of India. So Government of India is there, Parliament of India is there, Government of States, then the legislature of the states, So Government of India, Parliament of India, Government of States, Legislature of each states, and then you have the local authorities, and then you have other authorities such as it can be statutory authorities or it can be non-statutory authorities. For example, LIC, ONGC, these are also under the definition of state mentioned in Article 12. Now let's assume there is a private body, and this private body is working as an instrument of state. So this is a private body, but this private body is working as an instrument of the state. Then this private body will be under the definition mentioned under Article 12. This is said by Supreme Court. So this private body acting as an instrument of the state falls under the definition of state under Article 12. This is held by Supreme Court of India. Now we will read Article 13. What Article 13 is saying is that what is the date of commencement of Indian Constitution? So Indian Constitution came into force on 26 January 1950. Now before this date, there were various laws that were in force in the territory of India. So all those laws which were in force in the territory of India immediately before the commencement of Indian Constitution, that means before 26 January 1950, all these laws will continue to remain in force until and unless it violates any provision of fundamental rights. That means if these laws are not violating the provisions of fundamental rights, then these laws can continue. So this is Article 13. In Article 13, it is also mentioned that if after this date any laws are passed by the legislature, then these laws which are passed by the legislature should not violate the fundamental right. If these laws violate the fundamental rights, then the judiciary will strike down this law and will make this law unconstitutional. That means you can understand from Article 13 we are getting the concept of judicial review as well. Now when I am saying law, then this law includes ordinances, it includes order, it includes bylaws, it includes rules, regulations, notifications, customs. So, and those customs uses that are having in the territory of India the force of law. So all these are mentioned under law in Article 13. So when I am saying any law that is passed by the Parliament, if that law is violating the fundamental rights, that law will be declared unconstitutional. Does that mean fundamental rights cannot be amended? So the question is whether the fundamental rights can be amended or not. Now we have already seen just few minutes back that through 44th Constitutional Amendment Act 1978, right to property was deleted from the list of fundamental rights. That means you can understand obviously fundamental rights can be amended, but this fundamental right cannot be amended by ordinary law passed by Parliament. If you have to amend fundamental right, then you can amend fundamental right by Constitutional Amendment Act. That means if you want to amend the fundamental right, you have to amend it by constitutional amendment, and the procedure mentioned under Article 368. Now I am not saying this is mentioned in Article 13 itself, that fundamental rights you can amend through Constitutional Amendment Act. And this provision was originally not there in Article 13. It was inserted in Article 13 via 24th Constitutional Amendment Act 1971. So this is all for Article 12 and Article 13 mentioned in Fundamental Right of Indian Constitution.